introduce myself and then briefly introduce the speakers, and then they can introduce themselves when they are speaking as well. So my name is Jim Keller. I am the chair of the higher education practice at Saul, Ewing, Arnstein, and Lair. Our firm, you may know some of the folks at our firm, and I know we've worked with some of you in the past. We have offices from Boston down to Florida, out now to Minneapolis. My co-presenters today, Zach Berk, is a partner in our Boston office, member of our higher education practice, and handles complex commercial litigation matters. Natashia Tidwell, also in our Boston office, recently joined us from the Hogan Lovells firm. And Natashia is in, as I said, the higher ed practice, our white collar and governmental litigation practice, and has an extensive background both in law and law enforcement. So that's who we are. And I'm going to kick it off by talking about the game plan for the next hour. And then I think I'll let Zach and Natashia do a more robust introduction when they speak. So what's the game plan? The game plan is to go through these cases at a high level, to talk through some substantive defenses that you may have, both to the merits of these class action cases and the class action portion of these class action cases, give some practical tips, and then do some Q&A. So that's the high level overview. Why we're here is, as I suspect you are all aware, in mid-March, there was a single lawsuit filed, a single class action lawsuit filed against the Arizona Board of Regents, claiming that students who were sent home should be provided with some refund of tuition, room and board, and or fees. And totally coincidentally, and the only reason I mentioned it, the day before that class action lawsuit was filed, I had an interview with a reporter at the Wall Street Journal who was asking, hey, do you think there will be lawsuits about refund of tuition? And I said naively, I just don't really see that happening. I mean, these students are still getting credit, right? And I don't know, that seems like a relative long shot. I admit that I was wrong on that one. Next day, one lawsuit was filed, and now we're up to over 110. And I saw 3 more were filed this morning. So what we'd like to do today is give you some background. So one, if you've been sued or you may be sued, and I hate to say it, but it's likely virtually every higher education institution is going to see one of these eventually. You have some sense of what's coming. So next slide, please. All right, so what's an overview of these cases? As I said, there are more than 100. In fact, there were more than 100 when we drafted this yesterday. They're now closer to 110. New cases are being filed every day. They're being filed primarily in federal court under the Class Action Fairness Act, but some are being filed in state court. There are almost certainly some. So I won't show you my home office, but I have a stack of every case. We've been printing them out and reading them. I've learned there are some that don't hit an electronic docket. So some of these cases have been filed in a local county courthouse and they still use old-fashioned paper filing. So there are probably even more that we may not know about. Who is being sued? What types of institutions? Everyone. Publics, privates, big, small, and as I said, federal court and state court. One takeaway is these complaints are pretty easy to draft at this point. Plaintiffs' attorneys are pretty clearly cutting and pasting the exact same introduction, jurisdictional statement, substantive claims, class action claims, and they're just changing the names of the school and the parties. So from the plaintiff bar perspective, these are not a super heavy lift to file. Next slide, please. So what do we know about these claims at again, a high level and in summary. Are these cases different? Sure. But they really do fall into one of three buckets. And some complaints have all three buckets. Some complaints have one of these buckets. Some may have one or two. But the allegation is I paid tuition, or I paid housing and room and board, or I paid for certain student fees for the spring of 2020 semester, or if you're on a quarter system, which not a lot of schools are, but some are, for the spring Q1 or Q2 semester. And I'm not getting the full benefit of the thing I paid for, and you either haven't refunded me anything, you haven't refunded me enough, or on the tuition side, there's a qualitative difference between what I paid for, which was an on-campus class, and what I'm getting, which is an online class, and I should get some money back. So let me just spend another second or two on each of these. Actually, yeah, I just want to spend another second on each of these different buckets. So the housing and room and board and fee claims are pretty simple to understand, right? You could talk to anyone on the street and it would make some conceptual sense. I'm not saying it's necessarily a valid breach of contract or unjust enrichment claim, which is how they're being phrased. But if I walked down the street and said to my neighbor, hey, my child is at X university and we paid $5,000 for a dorm for the spring. They were only there for half the spring, but the college is keeping the money. What do you think? They'd probably say, well, that doesn't sound right. You should get half the money back. The fee piece, again, conceptually is pretty easy to understand. I paid, so I'll use an example, and it's an overly simplistic example. I pay $2,000 for a aquatic center fee to use the on-campus aquatic center. And I could only use the aquatic center for half the semester. I should get $1,000 back. We all know the world is not that simple. These fees get applied up front at the beginning of the spring. They're probably already sunk. It's not like you're allocating $1 every day somebody goes to the gym or goes to the pool. But again, conceptually, those are pretty easy to understand. The tuition piece is trickier, and I really think that's where most of the litigation is going to be fought, both substantively from a class perspective and if they get that far in terms of expert witnesses. Again, the argument is not necessarily that I should get all of my money back, because if I'm you, I'd say, okay, you want all of your money back, you're not going to get credit. And I don't think that's really what these plaintiffs want. They want the credit, but they want money back because they're arguing, I paid X dollars in tuition for this exact type of class, and this exact type of class had classroom instruction or hands-on labs or both, and I'm not getting that. So what I'm getting now is in some qualitative way less valuable, and either you're breaching your contract by keeping that money or it's unjust for you to keep that money. The best I can tell you on the tuition claim, how that might be quantified, there's one case, and happy to send it to anyone who's interested, filed against Purdue University, where in the body of the complaint, the plaintiff's counsel cited to a study that the Brookings Institute did, I don't know, 5 or 6 years ago, where they specifically studied DeVry University, which has a pretty robust online learning and in-person learning program. And these Brookings Institute experts concluded that in fact online learning was less valuable than in-person learning and should be worth less. Because that's out there in a public pleading, I expect that that's what the plaintiff's bar is going to pick up on as their theory for damages. Next slide. So you may also wonder, Who are the people filing these cases? There are lots of different firms. As I said, there's well over 100 cases now, but there are 4 that are filing multiple cases. So I thought it just might be worth 2 or 3 minutes to talk about them to the extent you're either already up against them or you might be in the future. So the firm that has filed the most cases is Bursar and Fisher. They're based primarily in New York, but also have a Miami and an LA presence. Our firm's been up against them in some class action cases in the consumer product space, which is really where they do most of their work. And the basic take is solid, not spectacular firm, workhorses, but a pretty small shop. They only have about 22 lawyers. And right now they have over 30 cases that they filed all around the country, from Washington State to Florida to, I believe, Connecticut, certainly Massachusetts. So there's some question as to whether they can really handle all of these cases themselves, which might give you some strategic thoughts in terms of putting pressure on them, should that be who you're up against. The Anastopoulos law firm is a close second. They've also filed close to 30 cases now. They got out first. They're based in Charleston, South Carolina. They are literally, and I don't mean this to be demeaning, it's literal, they are a ambulance chasing type of law firm. You can see them late at night on cable TV, and they have those TV ads with an ambulance and sirens and a 1-800 number. That's who they are. They stumbled upon these cases, I believe, because the very first case or the second case that was filed, someone who worked at the law firm, their child is the named plaintiff. They realized, as I said, these cases are pretty easy to draft, and they got their 1-800 number out there, and there's a website that you can click on to submit a claim. So they have become a leader in this space. Every indication from colleagues we have in Charleston is that they're probably in over their heads, and they're going to need co-counsel to really see these cases through. Very quickly, Hagens Berman is a national class action law firm. That is a very good firm, very good reputation. They do have the substantive and manpower to see these cases through. And DiCello, Levitt, and Gutzler in Chicago, they filed the very first case against Arizona that I referenced. They have about 10 of these now. Not clear if they'll have more, but that's at a very high level who you might be up against if you see one of these cases. Okay, next slide, thank you. Who are the named plaintiffs? So in most of these cases, the actual person on the caption filing the claim is a student who was enrolled in spring 2020. But in at least 15 of these cases, and there may be more, I have to be honest, I have to check the recent filings, the parent of the student is the plaintiff. So they are suing on behalf of themselves and all other parents who paid tuition. As we will talk about briefly later, you might have a standing defense if that's your case, because there's good case law for sure in the First Circuit that says the obligation to pay tuition rests with the student. And if a parent chooses to pay it, good for them, but there's no contractual arrangement between the parent and the school in that regard. And any rights flow to the student, not the parent. And in at least one case, and I think it's an outlier, and I don't really understand it, both the student and the parent are co-plaintiffs. How are these? So these are, again, pled as class action cases. So that begs the question, who's in the class? How are these plaintiffs defining the class of people? In every case, there's what I'm calling the everybody class. It's everyone who was enrolled in spring 2020 at your institution, period. That gives you all kinds of challenges when you get to class certification, which we'll talk about. Virtually every case also pleads a state-specific subclass. So it's the everybody who was enrolled in spring 2020 class. And then in the alternative, Judge, we want you to certify a class of everyone in your case, Connecticut, who was enrolled at your school. And the reason why we think the plaintiff's lawyers are doing that, is if you try to certify a national class on state law claims, which is what these are state law breach of contract, unjust enrichment, and sometimes conversion claims. It gets complicated. The law is different, obviously, in all 50 states. So I think this is an effort to say, hey, judge, if that seems like too much, at least certify a class of everybody in, again, in your instance, Connecticut, and we'll apply Connecticut law and move forward from there. And then some of these cases, and that law firm in South Carolina I mentioned tends to do this in every case, they have a third step and they say, okay, we think the class should be everyone. If not, at least everybody in this state. And if not that, judge, certify a tuition class and or a housing class and or a dining services class and or a fee class. So they're seeking, if we can't get the big class, at least certify everybody who paid for housing and didn't get their money back, etc. Next slide. All right, so with this, I'm going to turn it over, I believe, to Zach Berk. And I'm going to
Thanks, Jim. I appreciate it. As Jim mentioned, I'm a partner in the litigation department in Boston. I'm a member of the higher education practice group and a member of the complex commercial litigation group. I'm also admitted in Connecticut. I've tried cases in Connecticut, so I am familiar with the court system down there and the laws to some extent. So what I'm going to start out talking about are some potential substantive defenses you may have to some of these claims. And first, I'm going to start talking about what you want to think about at the very outset when you get sued in one of these cases. And while it may be obvious, one of the first things you should do, as in any breach of contract case, is carefully review your agreement, and in this case, an enrollment agreement and maybe other agreements that are at issue, and determine if there are other documents that may constitute part of your contract with the plaintiffs here, and look at them very carefully. And I'll talk about this a little later because it's important when you look at the case law, but think about what promises were made, if any, and what specific promises were made regarding the education or whatever other services you may be providing to the plaintiffs. You know, it's unlikely that you promised in-person classes, but there may be something in the agreements that suggests that. You may have made promises regarding the types of classes that would be provided. There may have been simply a promise that if the student completed the coursework successfully, they'd get credits. Did you comply with that promise? Did you fulfill it? Take a look at the agreements to see what refund policy there might be. And does that policy apply to the current circumstances? Another important thing to look at is, do your agreements have integration clauses? And many of you may deal with these all the time. You may remember from law school, but the integration clause is the clause that says that this agreement reflects the entire understanding between the parties and supersedes all other representations and communications between the parties. And that may be very critical here to defend against claims of misrepresentations that were made outside the scope of the agreement, or maybe on your website or marketing materials, or some sort of fraud in the inducement type claims. Another thing you should think about at the outset is, and I've already alluded to this, what other representations have you made about your institution's educational experience? So again, take a look at your website, take a look at your marketing materials. What materials are provided to accepted students? Again, the contract usually governs, but these plaintiffs are going to try to really harp on any other representations you've made and say that they were not fulfilled for one reason or another. And lastly, at the beginning of any case, and you should be thinking about this now if you already haven't, make sure that you implement a litigation hold to preserve any potential evidence for these cases. Arguably, you're already on notice of them because they're all over the place at this point, and you should be able to see this coming. And I'm sure many of you have already received these demand letters, emails, those all trigger your obligation to implement the litigation hold. So start thinking about, and I'm sure again, you've probably already done this, what email custodians are there at your school who may have relevant information, and make sure that they preserve those documents. What other policies, what other types of documents do you want to preserve? You don't want to hand a plaintiff an easy spoliation argument just because you failed to preserve relevant evidence. So after sort of initially thinking about what you need to do to look at the case, one of the first steps in responding to a complaint is obviously thinking about, do you have a potential motion to dismiss? And this may be your ticket out of the case. You may win the case with a motion to dismiss, but at a minimum, filing a motion can narrow the issues. It can give you some leverage if you're open to settlement discussions for some reason. So you want to think about what arguments you can make. First and foremost, if the plaintiff's alleging a contract claim, is there actually a binding agreement between you and the plaintiffs? Maybe there's simply no agreement and their claim fails for that reason. Secondarily, if there is an agreement, maybe you have an argument that under the plain language of the agreement is unambiguous. You can argue there's been no breach of the agreement. You fulfilled all of your obligations as set forth in the agreement. For example, if the agreement says that one of your only obligations is to provide courses for credit, if you've transitioned to online learning, but you're still providing courses for credit, there's no breach there. Another thing to look at is if there are equitable claims, and we've seen those in some of these complaints. You might be able to get those dismissed. If in most jurisdictions, if you have a contract that covers the subject matter at issue in an equitable claim, you can't assert an equitable claim as a matter of law, and you have to sue under the contract. A couple of things Natashia, I think, is going to be speaking about in a little more detail later. Do you have a motion to dismiss based on subject matter jurisdiction? Does the plaintiff even have the right to be in the court that they've sued in? Improper venue, can you move to dismiss for improper venue? Do you want to dismiss for improper venue? You may want to be in the court that they've sued in, even if you may have an argument that it's improper. Think about the venue, think about the jury pool that's available in that venue, think about the judge that you have or may have in the venue, whether or not that's a judge you want on the case. Think about where your witnesses may be located and if the venue for some reason or another isn't convenient. Another thing to look at when you look at your enrollment agreement, and is something you could raise on a motion to dismiss, is a forum selection clause. If there's one of those in your agreement, is that something you want to take advantage of, or do you want to waive that? Because you're fine with the forum that you've been sued in. Jim already mentioned this one, the standing issue. You may have an argument to dismiss based on standing if, for example, the plaintiff is a parent who is not a party to the subject agreement. Now on to some good news. A lot of these cases and a lot of the allegations, and really the tuition allegation that Jim mentioned earlier, boils down to this concept of educational malpractice. One of the seminal cases in Connecticut, it's referenced here, it's the Gupta case. And these types of claims, they were described by the Connecticut Supreme Court in Gupta as a claim where the essence of the complaint is that an educational institution breached its agreement by failing to provide an effective education. And essentially that's what these allegations that online learning is not an effective education or not as effective as in-person learning. And now to the good news, courts, including the Connecticut courts, almost universally reject these types of claims, whether they're made in tort or under a contract, if they relate to this issue of the quality of the education. And it's not that it's a high threshold or a high bar for a plaintiff to show that they didn't receive the quality of education that they were expecting. It's that this is just fails to state a claim and it's just not actionable. So that could be the subject of a motion to dismiss, or potentially down the road, if you end up in discovery, a summary judgment motion. And the rationale for this by the judiciary is that the courts really are ill-equipped to analyze, whether or not certain teaching methods are sound or not. And they really don't want to have to define what constitutes a reasonable education program and describe and then determine if that standard has been breached. So that's the rationale behind this. Somewhat interesting, they can determine whether or not a brain surgeon had done surgery properly, but they can't do this. But I guess that's a discussion for another day, and it's a good thing for all of your institutions. Now, there are some exceptions. So in Gupta, the Connecticut Supreme Court recognized two specific situations where the court will entertain breach of contract allegations related to educational services. So the first circumstance is when there's an allegation of a failure, when there's a failure of an educational program in a, quote, fundamental respect, end quote. So what does that mean? In Gupta, the court gave an example, and the court said, an educational program fails in a fundamental respect if you are not offering any of the courses necessary to obtain a particular certification that you've said your student could obtain after the coursework. So that would be a fundamental failure. In the Gupta case, the plaintiff made that allegation, but the court ended up finding that really the plaintiff's allegation was nothing more than the education that was provided wasn't really good enough. And I think there's a strong analogy to be made to these tuition-based claims that, well, this may be an argument that the education is not good enough, but that's not a failure in a fundamental respect. The second situation where courts will entertain breach of contract claims is where there's a failure to fulfill a specific contractual promise that's distinct from an overall obligation to offer a reasonable program. That's obvious, it is what it says, if there's a specific contractual promise. So in Gupta, for example, again, the plaintiff alleged that the defendant hospital, and the plaintiff was enrolled in a residency program, the plaintiff claimed that the hospital was not properly accredited by all the necessary accrediting authorities as was promised in the enrollment agreement. And what happened was the court ended up dismissing that claim because the plaintiff, on summary judgment, because the plaintiff failed to provide any evidence that the institution had actually lost any accreditations or that any of their accreditations were in jeopardy. So like I said, summary judgment was granted, not a motion to dismiss, and they did have to engage in discovery there, but that could be a strong defense. Again, look at your contracts, what specific promises were made. And finally, courts, and the Gupta court touched on this as well, and this applies basically in every contract, but you can't act arbitrarily, capriciously, or in bad faith. This is a very high standard. I don't think it's going to apply in any of these types of cases, or let's hope it doesn't. But because the courts say, basically, if you have any rational basis whatsoever for your action, and here, responding to the pandemic and the government orders that arose out of that, if you have any rational basis for what you're doing, then it's not arbitrary, it's not in bad faith. So I don't think that should be a concern. A couple other defenses: impossibility, impracticability. This may be a defense to some of the housing or the fee type claims. They're really one and the same, but an impossibility defense excuses performance because of an unforeseen circumstances. Now, in order to prove impossibility, you need to show that the event that made the performance impossible or impracticable, there was an event that made the performance impossible, that the non-occurrence of that event was a basic assumption of the underlying contract, and that the event was no fault of the party raising the defense. And I think the key issue that the courts look at with this defense is really the foreseeability of what happened. So you'd be inclined to think that a pandemic is not foreseeable, but I've also had cases where this issue has arisen in other contexts, and courts sometimes find if you have a force majeure clause in your agreement that, well, the parties contemplated that something like this may happen, something unexpected, and the contract contemplated how to deal with that situation. Therefore, you can't raise impossibility. So check to see if you have a force majeure clause, and that might create a problem for this defense. You also may have defenses that the plaintiff's claims are void against public policy, and you might have some immunity defenses. So those are some other things to think about. At this point, I'm going to pass it over to Natasha to talk about potential procedural defenses that you may have.
Thanks, Zach. So I'm Natashia Tidwell. I'm also in the Boston office of Saul Ewing. I'm a recent arrival to Saul Ewing, and I will say that if you're contemplating transitioning law firms during a global pandemic, just think about it again before you take that leap. But I am in the higher education practice group as well as in the white collar practice group. I am not barred in Connecticut like Mr. Berk, but I was counsel for the Hartford School Board in the litigation coming out of the Chef decision to remedy racial segregation in the Hartford public schools. So I have some familiarity with the federal courts there, particularly the Bridgeport court. So now that Zach and Jim have done their piece, and Jack has provided sort of an overview of the defenses that make for exciting courtroom dramas and law and order episodes, I'm going to drag you back to civil procedure. So if you think of it in sort of, you've gotten the entree and the dessert already, now it's time to eat your Brussels sprouts. And no offense to those of you who like Brussels sprouts, I do not. So I'm just going to talk briefly about some of the procedural defenses. We've divided them into two categories. We've got jurisdictional defenses and the more specific class action related defenses. There's one particular argument that sort of straddles between in the class action world. So I'll highlight that again once we get there, but we're going to start with jurisdiction. Next slide, please. So the jurisdictional defenses, and so you begin at the beginning of all Civ Pro classes. Does this case present a federal question? Does the federal court even have jurisdiction over this? And as we recall, diversity jurisdiction is usually the primary vehicle by which these sort of cases get into federal court, where state law claims are raised. So diversity jurisdiction requires complete diversity among the parties. The citizenship of every plaintiff must be different from that of every defendant. However, in these cases, plaintiffs are seeking to proceed under the Class Action Fairness Act, which excuses some of the diversity jurisdiction requirements, and particularly specifically requires a minimum of 100 class members, and only diversity between any one plaintiff and any one defendant. And I will speak in a sec about the exception to that rule in a second, but generally speaking, the diversity, what would be required for diversity jurisdiction is waived under the Class Action Fairness Act if any one plaintiff and any one defendant are citizens of different places. And the final requirement is that the total damages must exceed $5 million in order to proceed under CAFA. So getting back to the exception, the 1/3 to 2/3 exception, the federal court can decline jurisdiction under CAFA if between 1/3 and 2/3 of the primary defendants, if all of the primary defendants and between 1/3 and 2/3 of the plaintiffs of the class members are citizens of the forum state. And so this may come up where the plaintiffs are students of your institution but are primarily in-state. You may have a way to proceed under CAFA if it seems the bulk of them are the class members are citizens of your particular state of Connecticut. Another thing you might want to consider, and I think Jim raised this at the beginning, is does your institution want to be in federal court? So you may have a basis to challenge federal court jurisdiction, but you may decide that you want to stay there. And in thinking about that, listed some of the things you might want to consider. The possibility of multiple actions. Do you anticipate more than one action? And if so, where does it make sense for you to litigate them? The timing is another piece. Which courts generally move faster, and is speed something that you want? In Massachusetts, where I primarily, the federal court move a little faster than the state courts, but it can depend on which type of case you are bringing. So that's another thing that you want to think about, whether or not A, you want this done with speed, and B, where's the best option for having that done. The next one is motions practice. What happens while motions are pending? In some state courts, discovery is not automatically stayed while a motion to dismiss is pending. And sometimes you'd have difficulty obtaining approval for a discovery while the motions are pending. That would take federal court, so that might be another consideration that you might have in deciding whether or not to seek to dismiss on jurisdictional grounds. And then take a look at your state class action rules that Connecticut recently amended, or sort of in the last 5 years, so amended its class action rules to be more in line with the full rules. So there may be much room for discussion there. Just want to make sure that everyone is still able to hear me. Zachary, and if you can still hear me, I've got a note.
I can hear you.
Okay,
It's getting a little choppy, but.
Okay. And so there may be some daylight or some strategic daylight between your state's class action rules and the federal class action rules. But as I said, in Connecticut, it doesn't seem that is particularly likely. Also, in terms of jurisdictional defenses, we talked a little bit, and I won't sort of beat them down or sort of belabor them, but the standing question is something that can come up, particularly as Zach and Jim have both raised. If parents are the ones who are bringing the suit, the benefit of the education was designed to inure to the contract between the institution and the student, and not to the parent. So there may be whether or not the question of whether or not the parent is actually has suffered any injury by the potential breach of contract claim. So that may be an avenue for a standing question. And then we talked also a little bit about venue. Again, this is another question. It may be more strategic than anything else, but whether or not you think that you have a better jury pool or some other venue is a more welcome place for a case. So moving on to class certification, and as I said, the Connecticut state statute on class action, there's not much daylight between the federal rule of procedure, or there may be some. You should also obviously take a look at the state statute. But in general, Federal Rule Civil Procedure 23A has these requirements for class certification. The numerosity, there has to be any classes that join is impracticable. There are questions of law or fact that are common to the class. The names of the representative parties are typical of the class. And finally, the representative parties will fairly and adequately protect the interest of the class. So in thinking particularly about numbers 2 and 3, the questions of law or fact common to the class and the representative parties are typical to the class, we move to the second part of class certification, which is section 23B, which says that 23A must be satisfied, and then has 3 other requirements that if the plaintiffs are able to meet 1 or more, then the class would be certified. So I'm going to highlight in particular the 3rd requirement, which essentially mirrors, or your arguments for dismissal under this one would mirror the 23A requirement of commonality and typicality. And so 23A, as you can see here, talks about whether whether questions of law common in the class predominate over questions affecting only one member. And so if we think about sort of the type of student who might be bringing these sorts of claims, or the broad spectrum of students who would be bringing these, a student in a graduate student program, or a student who has a particular major where there isn't a lot of lab work required or a lot of in-person learning required, may be on different footing than a student who who does the bulk of their education work both in person or requires sort of a hands-on interaction with the professors, or it requires them to be more on campus. And so where you can start to sort of carve out these distinctions between class members, this would sort of go into or feed into your argument that the class can't be maintained for failure to satisfy both the commonality and typicality requirements of 23A, as well as this provision within 23B. Let's see. So the students will argue that they have a common question of law, whether they are entitled to a refund for tuition and fees paid for the on-campus experience for the remainder of the semester. And they would argue that the representative students' claims would be typical of the claims of the class because they all arise from the same event, the decision of the school to move to online instruction. But that may be, as I said, your institution can probably counter that by arguing that this common question does not apply equally across the board to everyone in the class. So the kind of highly specific factual inquiry that would be required is not something that the class action framework was designed to litigate. And so that would be a potential opening for your institution to dismiss on that ground. And I think, next slide, I think, yep. So I'll turn it back over to Jim.
Hi, thanks, Natashia. So we've got a couple questions in. One I want to address real quick, and then I'm going to spend 30 seconds on this slide so we can get to some practical tips, which I think will be hopefully most beneficial for you. So one question is, what if we don't have an enrollment contract? So actually I lied, I'm going to touch on two. And yeah, not every institution has an enrollment contract. The short answer is, one, that should be part of your defense, but two, the plaintiff's going to say other documents that are sent or other representations you make form an implied in fact contract, or if there's not an implied in fact contract, it's still unjust for you to keep our money without providing services. So that's not a surefire end to the case, but it's certainly something you should raise. And then a really good and nuanced question. So some of you might be familiar with a relatively recent decision in the First Circuit involving Sacred Heart, and not calling out Sacred Heart, that's just who was involved in the case, involving clawback of tuition payments from a bankrupt parent, and whether a trustee it's a case involving a Ponzi scheme, could recover those, what they determined to be fraudulent payments from the university. And within that decision, there is some discussion about whether the parents are the proper party for purposes of considering whether this was a fraudulent transfer or the adult student was the proper party. That's a great question. I don't think that changes the breach of contract analysis. The standards for a fraudulent transfer in a bankruptcy proceeding are different, but I'm happy to, that's a complicated case in and of itself. I'm happy to talk to folks about the interplay between bankruptcy, tuition clawbacks, and breach of contracts offline for sure. So tackling those two, what are some of the other evolving trends real quick? Some institutions are being sued multiple times, not always in the same forum. Boston University, for example, has been sued 5 times now, 3 times in federal court, 1 time in state court, and 1 time in California. We'll see if that trend continues. There are obviously calls for legislative action, and this has been touched on briefly earlier. There's calls for immunity, not just for higher education, but for every employer or entity at the federal level, at the state level, and we'll have to see what happens. There is definitely the possibility of multi-district litigation. Very briefly, that means consolidating these cases nationally for certain purposes, and then they go back to their home jurisdictions for a trial if it gets that far. That doesn't just happen. Either a party has to seek multi-district litigation, or the judicial multi-district litigation panel can sua sponte issue an order and say, we think all these things should be combined. Hasn't happened yet. Do I think it's possible, maybe even probable? Yes, and that's a whole separate session on what multi-district litigation means. But something to keep in mind, these could be combined for certain discovery purposes and pretrial purposes. And then insurance coverage, these claims, interestingly, and I'm not sure what the strategy is, but they're generally being pled as breach of contract or unjust enrichment. There's usually not a tort claim, which typically means there's not going to be insurance coverage. Obviously, you need to talk to your own broker and your own insurer. So I don't know about your particular circumstance, but I don't know if that was intentional by the attorneys pleading these claims because they don't want insurers involved, or a mistake because oftentimes plaintiffs' lawyers want insurers involved because they know there will be more money there. I don't know, but insurance is definitely a factor, both in terms of any possible liability and retaining counsel. You may not have insurance coverage for that. So with that, I'm going to turn it back over to Zach and Natashia to take us home.
All right, thanks, Jim. I'm going to talk a little bit, and I'll try to, I know we're running short on time already, so I'll try to zip through this to some extent, but I wanted to first start talking about some tips for litigation preparation. So if you haven't been sued yet, and even if you have been sued, but if you haven't been sued, these are just some ideas to put you in the best position possible to deal with litigation. So first, it's important to gather and review your public communications, and making a timeline is also a helpful exercise. This graphic here makes my head spin a little bit, but that shows all of the potential communications that may be out there that you should be thinking about. And getting a handle on the timeline is important for several reasons. You want to be able to tell a coherent story in court in the light that's most favorable to your institution. You want to be able to avoid surprise. So you need to think about, when did conversations about COVID-19 first start on campus? What steps were taken? By whom? When were those steps taken? When and what type of guidance was issued by the government? And what was the response by your institution? And the communication piece is not only, what communications did you have regarding the pandemic, but also, as we discussed before, communications, you should be looking at communications related to representations your institution may have made about the educational services and other services that will be provided to your students. Another thing to think about is, and it's important, is to talk with your budget and finance experts. Now this is really key for a couple of reasons, but primarily to evaluate your exposure for potential damages. It's essential, and determining what exposure you may have is essential to determining both your litigation strategy and also your settlement strategy. Are there certain points that these plaintiffs are raising that you're willing to concede in a settlement? Are there other points that you really need to challenge at all costs because it would be financially devastating? Speaking with these people also will help you potentially find critical documents for your case analysis and for discovery. Bills, invoices, these may be part of your agreement with the plaintiffs. They may be considered separate contracts with the plaintiffs. Maybe you have an accord and satisfaction defense on some of these claims if things were paid after you changed your policies. Prepare and respond to student-parent complaints. I'm sure you're all doing this now, and I'm sure you have a great game plan for that. But if you haven't done this already, or something you may want to think about is whether or not you want to create a response team so your responses are consistent and well calibrated. I'm sure you're all doing that. Maybe you want to have a point person to provide responses so you have one single message. As part of these teams, you want to consider, and probably should have, your media relations people involved. If you have outside counsel, you might want to get outside counsel involved, because clearly one of the last things you want to do is make statements that are then going to come back to haunt you in litigation. You may also want to consider whether or not you have a separate internal complaint process. get a handle on applicable Connecticut law. This is obviously a good idea. I've given you, and Natasha, we've referred to some of the law. It's clearly not an exhaustive list. What other defenses might apply, what immunities might apply, what class certification defenses might you have? Does the Connecticut Unfair Trade Practices Act apply for any reason? What defenses might you have to a CUTPA claim? I'm sure every plaintiff's lawyer is going to try to figure out every possible way to assert one of these claims in Connecticut so they can increase their damages and potentially get attorney's fees. So that's something else to think about. Think about representation. Even if you haven't been sued yet, it's a good idea to think about whether or not you're going to need to hire outside counsel. And if so, what important qualities are you going to look for in outside counsel? Do you want someone who's a state law expert? Do you want somebody who's a higher education expert or has class action expertise or all of the above? Do you want to have a situation where you might want a local firm and some firm outside of Connecticut really managing the litigation? Jim mentioned this already. Is there incurred insurance coverage available here? You might want to think about what fee arrangements you want to enter into with counsel. Are there alternative fee arrangements that may be appropriate for these types of cases? Another thing to think about is, can you and should you coordinate with other institutions in your defense? Is there a way to enter into a common interest agreement that would keep your communications privileged? And do you want to do that? Something else to think about. And then finally, think about what Bill Belichick would do once he got sued. You want to be 10 steps ahead of the opponent. So you really need to think not just in the present, but what are you going to do down the road? What are you setting yourself up for? I already mentioned litigation holds, and everything else we discussed, the jurisdiction, the venue, the class certification issues, motions to dismiss. You might want to start thinking about discovery. Who do you want to depose? Who is likely going to be deposed by the plaintiffs at your institution? And you want to think about that in the context of setting up your case for summary judgment. Another key thing to really think about is how are you going to maintain privilege once you're sued? Who's going to be part of the group of people dealing with the outside counsel, and how are you going to maintain that privilege? And one other thing to think about is your PR strategy moving forward. What's that going to be as the case goes along? Now I'm going to pass it over to Natasha, I believe, to just discuss questions with regard to returning to campus.
Yeah, and this is Jim, and I'm sorry for interrupting, but I just want to use my moderator prerogative. We have 5 minutes, so I think 2 or 3 minutes, Natasha, on this, and then we'll leave a couple minutes for questions.
Yep, absolutely. Thanks, Jim. So just in thinking about returning to campus or whatever that is, just to plan in your mind just what changes may be appropriate for the fall. And I know there's been some discussion about sort of the potential for a legislative lifeline. It's largely fallen upon partisan lines, whether or not there'll be some liability, particularly in the employer context, if there's a return to campus or if offices reopen. There was just yesterday some discussion in the state of New Jersey amongst educators, amongst college presidents, urging the legislature to pass some sort of legislation to protect universities in the wake of all of these class action suits, and whether or not that would, that seems to go outside of sort of the tort area where Congress is looking at federally and may get into some of this breach of contract questions. So take a look and see if the Connecticut legislature is similarly being pushed in that way, or if your institutions want to do that. Next slide. And just to piggyback on what Zach was saying about your complaint process and who is responding to complaints and having a single message, just think about you want to continue outreach to parents and to students over the summer. You want be transparent, be honest, don't overcommit yourselves to anything that you don't know for sure. The last thing you want to do is be creating more procedures that would be a lawsuit saying that you breached your contract somehow. Next slide. So if it's going to be a new online world, which it seems as if the experts are correct that at least some or all of the fall instruction will be through distance learning, if we do have another wave in the fall. So both the ramifications for what that looks like if you are under suit, as well as if you are anticipating that you could be. So if you've got a pending class matter, next slide, you might want to think about if you have to switch to an online learning for the fall semester and you're contemplating some sort of tuition reduction based on that, does that qualify as some sort of subsequent remedial measure if you're under suit already? So could the plaintiff's attorney use that to say, well, you recognize that the value of online learning is less, and so therefore that helps our case, so you want to think about that. As Zach said before about your enrollment agreement, pick them up again and start to think about whether or not you're making any promises about what life will look like going forward. You may also, as Zach alluded to before when we were thinking about form selection, is this the time to start to think about adding clauses to your enrollment agreement about where such disputes would be handled, whether it be in arbitration or wherever it is, if politically, if your institution is ready to take that on at this stage. And that was it.
So thanks, Natashia and Zach. We've got about 3 minutes. So just one quick note on what Natashia mentioned. So when you're thinking about the fall, and I know you're all not going to do this, but don't make your decisions just based on fear of litigation, but you have to be aware these suits are out there. And if you make changes to your documents or to your pricing for online tuition, someone may say, aha, see, it proves it was worth less. So it's just something you need to be mindful of, and you may think about adding language, not just to enrollment contracts if you have them, but other communications that says, hey, by the way, going forward, the price is the same on campus, online, or hybrid as a protective measure. So there are a couple questions in the queue about the bankruptcy piece, which we'll tackle separately, happy to. One pretty simple question is there a good resource that compiles all of the pleadings? The answer is yes. So if you go on the SUNY system, Southern State University of New York Student Conduct Institute, you could just type it in Google. They have a running compilation of all of these cases. Our firm has one as well, but honestly, they've got, I think, 3 interns working around the clock tracking these. So it lists every single case, and I would commend that to you. So I think we have another minute or so for additional questions. If folks want to send them, I will moderate them. Could there be punitive damages in these cases? I don't. So that's actually a good question. Some of these complaints have a punitive damage count. There's no punitive damage component to a breach of contract claim. I can't imagine. I don't know. I can't see a court awarding punitive damages, and actually I think that's overreaching. And if you're sued and they have a punitive damage count, I would definitely attack that. Question is to whether I know of examples, we know of examples where schools are banding together to defend. I don't know if Zach and Natashia have other information. I can tell you that our law firm has been asked to respond to a proposal to represent multiple institutions in a state that's not Connecticut. That's probably as much as I can say. I don't know if that will actually happen, if that's how they're going to proceed, but some schools are definitely looking at joint representation. Those are all the questions in my queue, and I think we are at time. So thanks you to everyone for participating. Good luck, and there's our information if you'd like to get in contact with any of our offices.
Thank you, everyone.
Thank you.